We want to get started with our featured luncheon talk, and we're really very honored to have with us Paul Igasaki, who is the chair and chief judge of the Administrative Review Board and has been such for about a year now. He was previously the Deputy Chief Executive of Equal Justice Works Public Interest Group from 1994 to 2002. He was chair, vice chair, and commissioner at different times, I guess, of the EEOC under President Clinton. Served as executive director of the Asian Law Caucus in San Francisco. He was Washington representative of the Japanese American Citizens League and a liaison to Asian Americans for the mayor of Chicago, been around, and counsel to the Chicago Commission on Human Relations. Staff director of the American Bar Association Pro Bono Project, and staff attorney and fellow to Legal Services of Northern California in Sacramento. He's a graduate of Northwestern University and the University of California at Davis Law School. I'll give you Paul Igasaki.
Thank you. It's a pleasure to be here. It's interesting, I ran into someone at the conference here from my days at Northwestern. That's a long time ago. And I also was confused just a moment ago with Judge Corchado, who is my colleague at the Administrative Review Board. I think I just saw him poke his head in. That's the first time I've been confused with Judge Corchado. I find that I'm usually confused with Judge Ito more often. But as a federal appointee, I'm obligated to give you some caveats, something that I get used to doing a lot. I speak for myself. I do not speak for the Department of Labor or Secretary Hilda Solis or anyone else over at the Department of Labor or Justice, for that matter, I suppose. Since I need to objectively review and decide cases before us and our decisions as a board, that's our decisions as a board, the way we speak about policy. I can't specifically interpret the Food Safety Act, nor can I speak about any cases that are in front of us. So why do you want me here? I think your organizers can answer that. But I think the Food Safety Modernization Act is a recent law, as you all know. Other laws under our jurisdiction have been in place for many months or even years before we see any cases. Some laws produce a great number of cases before us, others very few. So it should be no surprise then that we have received no cases under the Act to date, nor do we expect to for some time, but we will. So while my thoughts here today are based upon work of at the department, and to some degree my work at EEOC or outside government, I'll look more broadly at the whistleblower process and how it works, and the role of the Administrative Review Board, which those of you who are going to pursue some of the cases here may have some knowledge or interest in knowing more about. Things such as things take time, and what you might need to expect, and what you might hear about when your case will be heard. Whistleblower protections are a relatively recent legal phenomena. Without whistleblower provisions, a problem could sit there and it has to actually occur before you can have a lawsuit about it. Then you have a tort action with damages and that sort of thing. But it certainly could lead to change practice ultimately, because if it costs a company money, maybe they'll change their practice. But depending on the law, it's essentially closing the barn door after the horse has gotten out. Whistleblowers are within the American tradition of individualism. While support or non-support of unions are sometimes seen as a partisan issue, various kinds of labor employment issues are seen, you're either pro-company or pro-worker. a woman or a man standing alone for what's right against an institution that has overlooked that due to its interest of profit or reputation, that's really an all-American kind of tradition, something that if you look at our movies, look at Mr. Smith Goes to Washington, or our realities, Frank Serpico calling out the police corruption issues in New York, Karen Silkwood complaining of nuclear contamination, John Dean in Deep Throat on the Watergate case. Congress continues to pass whistleblower laws in one area after another. Well, Congress right now, at least the House side, is in a state of change. There's no reason to expect that the growth in whistleblower practices or processes is going to end. So indeed, at least with the more traditional leadership on the Hill, both Republicans and Democrats have demonstrated support for whistleblower practices and systems. So I think we'll see more and more of it. So even if you're working in one area or another, knowing about that is something that could be very valuable. And in fact, there are very few people who are expert in it. Whistleblowers are people inside an organization that see something problematic and call attention to that problem. In the best of all worlds, the company or agency that appreciates what's going on, sees the concern, corrects it, and recognizes or at least doesn't retaliate against an employee that brought it forward. In these kind of situations, we won't ever hear about it. It does occur. How often, I can't say, but that's the ideal. In so many situations, nobody outside an organization would know anything about it. It's things go on, and if people brush it under the table or are afraid of coming forward on it, it just goes forward into something dramatic happens. A plane crashing, someone getting poisoned, something significant like that. And that's when the post-fact lawsuit becomes an approach. But whistleblower actions have been developed to avoid that. A strong, healthy organization will embrace people who bring forward problems. There are so many other pressures on companies or government agencies for that not to occur. So often, while in the midst of something, a company or a government can convince itself that we can keep this quiet and no one will find out about it, or few people will find out about it. While it's arguable that consumers might appreciate an honest company, the immediate damage to reputation may carry too much of a financial loss, and one's superiors may see their careers being disadvantaged if they've allowed this to occur. Whatever the reasons, whistleblower complaints are there, valid or not, and they're a growing reality. Consider the many whistleblower laws that we enforce. In some, worker safety is a priority. So in the trucking industry, we got a lot of cases because in the trucking area, if you file a complaint under that law and you have your administrative hearing, it automatically comes to us. So we used to see a lot of those. That's on being reduced now because now you have to request the appeal. But a good number of cases were in the trucking area. There's a railroad safety law, which is, my friends on the Teamsters side have told me that we're getting lots of complaints. We haven't seen them yet. So it's a relatively new law. Cases work their way up through the process. But most of these cases in the trucking and the railroad industry are about worker safety. Not exclusively, but primarily about worker safety. There are other cases that involve transportation that are a little less on worker safety and a little more on public safety, and like the airline law, Air 21, where a mechanic, for example, may report a problem. The idea of why you want to catch those situations before they go wrong are pretty obvious in the airline industry. But there we're talking about public safety. Some of the laws that we hear whistleblower complaints on involve the environment, the Clean Water Act, radiation. We've seen a fair number of radiation cases. So there are a number of areas where you can see the public good or the public interest being advanced by someone coming forward. And again, it's something where one can see why you want to have something dealt with before the bad thing happens. Most recently, with the collapse of some of our financial institutions that led to the economic crisis that we're still in, Congress passed the Sarbanes-Oxley law, and most recently the Dodd-Frank law, that provided legal liability for financial abuses and fraud, but also providing whistleblower protections for people who come forward. So that's another law that comes in front of us. In the classic whistleblower situation, an employee complains of an abuse that they become aware of, either in bringing it to the attention of their supervisor or perhaps the government agency or even the press. The employee faces job action that they allege is because of their whistleblower activity. That action could be reduced pay, it could be suspension, or ultimately, and most commonly, job loss. If that is the case, then the employee or the employer may have to reinstate the employee if they're held liable, or perhaps pay damages or take some other action. The company will undoubtedly claim that there was either no protected activity occurred, for example, saying that, well, maybe the employee said they knew about this, but they never told us or never told anyone could do anything about it. Then they may also claim that the person was fired for some other reason. For example, yes, he said he complained, he did complain, or he didn't complain, but we really fired him for work performance, or we fired him because, and this is much more common with our cases, he doesn't get along or she doesn't get along with others. So under whistleblower laws, we're not in a position to rule against firing for bad reasons, but only for actions in retaliation for protected activity. So there are a lot of times where I shake my head about, gosh, the manager did that, but then I also feel that it doesn't reach the standards that we have to apply, so we can't really take action. Sometimes you will see, for example, a case recently we saw that was before us, similar issues coming up before the National Labor Relations Board, or perhaps the EEOC or some other entity for different kinds of issues. But we only are empowered to deal with cases in our area. Now, why is it so important to protect those willing to come forward? Often there's little motivation for people who do, other than altruism. And it does take a lot to stick your neck out. If they complained of a situation could hurt the company or an agency's reputation or otherwise cost them money, management could have a reason to retaliate. And even if not, it hurts your reputation with the company, so why risk it? It's true with any kind of complaint one brings or legal action one brings that you take a risk. Once someone knows you're willing to do this, you're willing to stick your neck out, right or wrong, some employers will say, this person's a troublemaker, and we won't hire them, or we don't want them. And so that's why these laws have developed, so that there's some protection, not completely, not enough in some cases, but something that will help provide some zone of safety, so that if you find something that you think is wrong, that there's some reason to believe that you'll be protected. Nobody likes a troublemaker, is the phrase. And indeed, one of the biggest excuses that I mentioned earlier was for firing an alleged whistleblower is they don't get along with others. There's an old Buddhist saying that the person who calls attention to themselves sticks out like a nail in a board and they get hammered. Whistleblower laws are intended to change that balance and to assure employees that, yes, you're taking a risk, and no, there are no guarantees, but there are tools. We exist to make sure that that balance is there. Sometimes the persons with the courage to come forward are people who do stick out. Sometimes they complain about things that aren't worthy of legal protection. Sometimes they complain seemingly about everything. But that doesn't mean that the next time the person who may be a pain, and as a manager say, gosh, I would never hire this person, that next time they complain, they may be the only person willing to stick their neck out in a corporate culture that's extremely averse to coming forward. That person who's got their chip on their shoulder may be the only person willing to bring that fact forward. And you have to be ready to look for that. I mean, we have to be ready to consider that, because we're not deciding in cases this person's a good person or a bad person. Again, it's did this person take protected activity under the law, so they should be protected. If the corporate culture doesn't promote people to come forward, it's all the harder. And it's true that sometimes the cases that get to us, and actually a lot of them don't even get to us because they don't get appealed, but some of the people who are willing to appeal a case are also the people who are willing to come forward. So some of the cases, they believe that? So we do turn around cases where the cases are not strong enough. But there is no law against firing a person who doesn't get along with their coworkers unless you discriminate or retaliate. Generally, a whistleblower needs to perform his or her function, whether that be complaining to superiors about an unsafe condition, talking to a government agency about a law or regulation, or similar acts that are protected activity. Once you establish that, if the employer acts and it is due to that activity, there could be retaliation or discrimination. It gets a little confused. You know, as you heard in my introduction, I used to work at the EEOC. There, the term discrimination is you discriminating against someone based on their characteristics, their gender, their race, their nationality, their age, their disability. It's a slightly different situation to discriminate against someone for their protected activity. The result is the same. You end up losing your job or you lose a job benefit. But the standards aren't exactly the same. And we use a lot of, those people who are lawyers know that a lot of Title VII law gets imported into our area. And sometimes that's appropriate and sometimes not. And that's kind of what we do for a living at the ARB, is sort that through. And that's one of the reasons I think they put me there, because I have an EEO background to make some of those determinations. Generally, a whistleblower, I just talked about that, but the remedy usually in these situations is going to be reinstatement. Because while people can bring actions for other kinds of job benefits getting cut back, the fact of the matter is, and this is true in the EEO as well, there's no incentive to come forward if you still have that job. Because you take the hit. Most people are willing to take the hit with a salary reduction or take the hit for an assignment that isn't quite as desirable as they have, even though the law might protect them. But most people are willing to say, if this was wrong and I lost my job, then I will pursue it. And so that's why most cases that we do see involve job loss. And most of the resolutions involve reinstatement. Now, sometimes people don't want reinstatement because it's such a soured relationship that you don't want to go back into it. But we still start, and this is by legal standard, we start with the resolution of being reinstatement in your job. And then we may move to damages or something else, but that's where we start. All of this is within the context of administrative law. Now, those of you who are lawyers, this is old hat and it's kind of superficial. But for those of you who aren't, it's a little different when you come through the administrative law system than when you come through the regular courtroom system at state and federal levels. The need to protect people's rights has expanded in our complex society. And already our federal and state trial system with juries and all those sorts of things takes so much time to do the cases that are in front of them. If we, for example, were to have all of denials of Social Security benefits coming before the federal district courts, we'd have to triple or quadruple the number of judges we out there. And as it happens, my wife is a Social Security appellate administrative judge. And as it happens, they're tremendously overworked as it is. So the idea is administrative law is going to bring cases forward and have them flow more efficiently. Flow more efficiently because, one, there's relaxed standards of evidence, relaxed formalities. You don't get a jury, you get an administrative hearing officer or administrative law judge. You do have witnesses, but the laws of evidence are a little more relaxed. Also, in theory, and I say this is in theory because we're kind of an example of this. In theory, the hearing body will have greater expertise. So they'll understand the technicalities and that sort of thing. That's true. You know, my wife had Social Security. She knows all these things about medicine and ailments and disabilities, but even though she's a lawyer, not a doctor. For us, though, ARB is a little different. We have some 50-something laws that come up to us. So some of them we have better knowledge or experience of than others. Now, majority of the cases that we see are whistleblower cases, but then whistleblower cases, as I mentioned earlier, come from a wide range of backgrounds. So we learn a lot about the airline industry. I know more about the trucking industry than I ever did a year ago. We're learning fast about securities law. So we struggle to keep on top of these things, but these things do change. We also, in administrative law, have certain procedures we follow. In the regular trial system, you have the federal rules of civil procedure and their state counterparts. There is an Administrative Procedures Act that is kind of a backstop for basic procedures. But if you look at the rules behind every statute that comes before us, some 51 statutes, as I mentioned, they have different rules. And so sometimes that can be a little challenging. To practitioners, all the more so. I see a few of you in the audience, so you have to become expert in that. One of the things that we're doing now, this administration is doing, is trying to consolidate and regularize our procedures as much as we can. So we've drafted a document with input from many of the stakeholders in this area. So we have regular procedures, so the rules will be as similar as possible, except to the extent that Congress has mandated certain rules, which is actually a fair number of cases. So that does allow us to move more quickly, but people who truly are expert would chuckle to hear me say that I'm an expert on securities law. We rely upon, we have some cases that come up for us under the SOX Act where we beg for Securities and Exchange Commission to file amicus briefs. That way we can get some expert input on it, and that helps us a lot. But more often, one of the things we rely heavily on are the advocates to bring us, and even the claimants, to bring us their expertise, and then we assess that expertise, because so many of the standards are reasonable person standards. Those of you who are lawyers or law students know the reasonable person standard kind of stretches across the law, absolutely. And in my life, I wait to meet the reasonable person, but that's a standard that we end up applying quite a bit. At the same time, since administrative law is designed to move cases quickly, backlogs occur also. You know, my wife tells me how enormous their backlog is, and since she works on weekends and evenings and whatever else to move those cases, I believe them. So part of the problem with backlogs has to do with staffing. So we have all those laws that come before us. My team, there are 5 judges in our board. We have 1 vacancy right now, which I expect to be filled before too long. We have 6 lawyers working with us. We have 1 vacancy, which I'm told, given the budget situation, I won't be able to fill, at least for the foreseeable future. One of the things that has enticed me here was knowing that the administration had desired to bring on 2 additional attorneys, which would bring us up to a greater strength. But with the current political situation and fiscal year 11 budget, which should have started in October, is probably dead on arrival. So we'll do the best we can, and we do want to chop down on our backlog, but it's kind of a problem. We'll do the best we can. At the EEOC, it's a little different scheme of things. We get a matter of several hundred cases on our desk. EEOC has 80 to 100,000 cases crossing theirs. So it's a slightly different thing. But at EEOC, we were able to chop the backlog down almost in half and reduced by almost a year the average processing time. But there, frankly, our predecessors hadn't been as efficient as they should. And also we had reasonable resources that allow us to focus a little more. It's harder for us. Now, at the Department of Labor, the Administrative Review Board is a relatively small little rowboat in a big ship. I've never worked in a building that large. We have our own post office and that sort of thing. You have your wage and hour people over here. We have the federal contract compliance over here. There are only 3 bodies that are deputized to hear administrative appeals. There's us, and we hear appeals on the bulk of labor areas. There are 2 other panels, actually have more cases than us, but they have very focused agendas. One does federal employee worker compensation appeals, and the other does longshore and black lung benefits, both very important and fair amount of numbers of cases, but they can really specialize as opposed to what we do. Majority of our cases, as I said, are whistleblower. But of those whistleblowers, of all those categories I talked about, they kind of pepper through all those categories. So when I got here, the trucking cases were everything. They've gone down, and the Sarbanes-Oxley cases have gone up. We may be getting more railroad cases. It's just hard to predict where it's going to go. And it's always interesting to see what our next case is about. Because not only do we get the whistleblower cases, we get Davis-Bacon wage and hour cases. We get H-1B immigration cases. We get farm labor cases. We get, well, there are a number of other things that show up that we've never seen before. So it's always interesting, and certainly one of the things I've shared with my friends about this job is that sometimes I feel like I'm in law school again, because I'm learning a lot very quickly, although I do find that you learn a lot quicker when there are real people and real facts involved. So my law professors would be surprised how well I learn now when I have real cases to look at. Now, if someone gets a decision from us, some of those decisions will involve us saying, okay, here's what we rule on the law, but you applied this part of the law wrong, so you have to go back down and have another hearing. I don't like to do that because it wastes a lot of resources. If we can make a decision on the law and be done with it, that's great, but a lot of times our authority only allows us to say, you go back and hear this again. You applied the law wrong, bring it back to us again. And we try to give them enough guideposts so they don't go over and do it all over again, because that could be a little circuitous, and sometimes it happens anyway. But in any case, the administrative law judges that feed cases to us, they have the same large number of cases we hear, and then a few additional. So it's a challenge to them. However, their staffing is such, each of them have clerks of their own, which is something that our judges don't have. So we don't lose a lot of sleep over overturning their decisions. But if you don't like our decisions, you want to appeal it, most of those cases have to be appealed to U.S. Courts of Appeals, which could be costly and time-consuming, but that's where they go. We have a pretty good record up there, but a lot depends on what kind of decisions we're making. This is a relatively new, I've been there a year. My colleagues have been there a shorter amount of time, except for my deputy who was there a month longer than me. So we'll see over time how our batting average is with the Courts of Appeals. I suspect they will overturn some of our decisions, and we're not afraid of that, but we do try to make the law stick as much as we can, so we hope that we'll be successful with that. Most of the cases, as I said, come to us from administrative law judges. Some of them come directly from the wage and hour administrator of the Department of Labor, so if it's a Davis-Bacon prevailing wage case, those come to us. From a Department of Labor department as opposed to a judge. Similarly, some cases come from the Office of Federal Contract Compliance, and they come to us as well. So things do come at us from all sides. The interesting thing about the work that we do, though, is that at the appellate level, we don't hear witnesses. We don't see new evidence. We review what's in the record that was developed by the judge, and we apply the law as we see the law. So most of our cases are in our office, so we don't necessarily have the need of a courtroom or anything. Last month we had our first hearing of oral arguments from parties. The third time in the history of the agency, and the first time, I think, in many years. But it was because it was a big issue. We're considering whether we might change law or not, or change our precedent or not. So we wanted to make sure we heard everything. And even though going in, we thought we knew everything we knew about the case, we learned new things. And I think it has had an impact on our thinking, which means we may have more oral arguments in the future, but we'll still be sparing about it. It does take a lot of extra time and want to move as quickly as we can. Before the ARB existed, these decisions were made by a unit of the Secretary of Labor. And pieces of it were held by other bodies. And so at one point they decided to consolidate all of that and then remove it from the Secretary's office. The Secretary still appoints us, but people are appointed for a term, although very short, 2-year terms is one of the shortest terms in the federal government. But generally speaking, what that really means is as long as your Secretary's administration continues, you probably will be continuing as well, and at least until the completion of your terms. So like other appointments, you change jobs a lot. It's part of the reality. One reason I'm very happy to be here today is because we try to communicate as much as possible what our standards are and what our interests are and what we do. When I was at the EEOC, you got covered in the media constantly. You know, it's we did the Mitsubishi Motors sexual harassment case. And I was on television maybe 6 or 7 times. I went to Japan, I was in television there as well. So people follow EEO, which is as it should be. They don't really follow labor law and whistleblower law as closely. It really takes a claimant who has seized the media's eye to bring them forward, and even then, it's not us that's going to be covered, but the individual. And even then, the administrative law system doesn't really promote the same level of publicity. But nevertheless, we do have our impact and our ability to make decisions. But what it does make political outreach, public outreach important from my point of view, is that not enough people know about what our rules are and how we operate. Most of the people who come before us are represented. But a good number, and more than a lot of areas, are people who are unrepresented, so there's pro se claimants. That makes it really hard because the rules of administrative law are very precise. They say you've got to do this, but do this by then, do it this way in this form. And we try to spell it out as much as possible, but it's very hard for a non-lawyer to figure out some of this stuff. Yet we still have to apply the standards that are given us by the law. That's why I like to see more and more experienced advocates out there on all sides. Whereas at EEOC, some other places, I found that the companies generally always were very well represented, and the claimants often were not. But that's not true in the whistleblower area. People may be represented on both sides, but many times the attorneys for claimants and for companies know very little about whistleblower law and relatively little about our standards, and it makes that much more work for us. But if you have a lawyer, good or bad, we're going to hold you to a tougher standard than if you're on your own. So there's a very small group of plaintiffs experts who focus on whistleblower law. A couple of them are in this room. And there may be a handful of others around the country. There simply is not a large whistleblower stable of advocates on the complainant side. On the defense side, the same is true. Some of the really big defense firms, Safer, a few others, they have someone who specializes on whistleblower. But a lot of other defense firms have nobody. And so when you look at moderate size from a smaller city firm, they may know EEO, but relatively few of those firms have anyone with whistleblower law background. And that results in disadvantage to their clients as well, and sometimes means we end up battling about procedure issues that we shouldn't have to be worrying about. So that's why I appreciate the interest of community of advocates like this, companies, and anyone else who wants to know more about this. And I don't get invited to the ABA meetings as much as I did when I was at the EEOC. So anytime I see the opportunities like this, I kind of jump at it, even though there are a lot of rules about what I can say and what I can't say. So with all that, I do appreciate your interest and commitment to this law. It's my pleasure to serve our nation in this capacity I'm in at this time. So as your employee, I want to thank you for this opportunity. I wish you luck in helping this new law serve its purposes. In my role, I have to be objective as to result in any single case. But I do believe in the laws that we enforce. And within the law and its requirements, I take seriously our duty to make them work as they were intended. And to be perfectly frank, there's so much on Congress's plate, they don't always think about all the things that need to be put down and decided before a law is put forward. So that's why it's necessary to have appellate bodies such as ours. And it is our job and our interest to see these laws speak and their spirit to be effectuated in the way most intended by the American people. So I thank you as well for your interest in food safety modernization and its effective implementation. Thank you very much.